The fact is you are deliberately designing your algorithms to maximize the exposure of different classes of content, and that is what's causing the harm. So it's more of a product liability case than a case connected with publishing.
Now, a landmark trial is set to begin today in California, where a 19-year-old plaintiff is taking the owners of social media sites such as Facebook, Instagram, YouTube, and TikTok to court, alleging the design of the platform's algorithms left her addicted to social media and negatively affected her mental health. Mark Zuckerberg is among those expected to testify. Let's speak now to John Carr, former vice president of MySpace and one of the world's leading authorities on young people's use of the internet. John, good morning.
Good morning.
Thanks for being with us. So look, this case focuses specifically on the design of these sites and the use of algorithms rather than the questions of what's actually posted on them. How significant is that distinction?
Hugely significant, and this is truly a landmark case. Under US federal law, and we have a similar law here and in the rest of Europe, a social media platform cannot be taken to court for something that a third party put up. So if I publish something defamatory or illegal, there's nothing that anybody can do, as it were, against the platform. They have no responsibility for it. But what's being suggested here is that let's leave aside the question of what the content is. The fact is you are deliberately designing your algorithms to maximize the exposure of different classes of content, and that is what's causing the harm. So it's more of a product liability case than a case connected with publishing.
And is the case here that, as you say, it's maximizing different types of content, and these types of content can be harmful and people are seeing a lot of them? Or is it about I guess it's in a way the same thing, but the addictive mechanisms of these sites, the way they're so hard to turn off, the way they're so hard to forget about?
Precisely. What the plaintiffs are alleging is that the platforms either do know or should have known that the way their algorithms are working is in and of itself and without more the reason why so many children are being harmed, and that therefore they have a product liability obligation to try and address that and reduce it or eliminate it, and they haven't done so. So it's a very, very big deal. There's no question about that.
This might be quite a fine distinction, but would proving addiction here be the same thing as proving harm? Because I suppose the platforms could say, yes, we're compulsive. Yes, people find it very hard to turn away from our sites, but that's just because they're amazing and it's not really hurting anybody.
That would be an important distinction if it could be made. I think it will, and it will certainly be argued. But the fact is, we know that children, certainly significant numbers of children, not all children, but significant numbers of children, when they get into doom scrolling loops where sad content after sad. The Holly Russell case in the UK was one of the classic examples where the coroner said there is no question in his mind that the fact that all of that content was constantly being repeated and sent to Molly, irrespective of whether she was actively seeking it, it was the algorithms that were pushing it, was the reason why she, in the end, committed suicide.
So what could this trial mean then for how social media companies might be regulated in the future? Because this sounds like this could lead to some kind of structural regulation that isn't about content regulation.
No, it's definitely not about content regulation. That's a whole other ball game. We're addressing it here in the United Kingdom with the Online Safety Act, but the United States is a very long way from that. But if this case wins, bear in mind, most of the cases that people have tried to bring up to now have never got to court because an administrative judge has basically said, Section 230 of the Communications Decency Act, 1996, which is the relevant law, simply says you have no possibility of winning. In this case, a judge has said you do have a case. There is a possibility that product liability will be a good argument. And if it succeeds, then obviously everybody who's designing algorithms, this is going to have particular impact in the world of AI, is going to have to think about the real world effect of what those algorithms are doing. And you can't simply hide behind the fact that the content being served up is being created by somebody else.
John, look, this is happening at the same time as well. Other things are happening in Europe. Governments are considering banning social media for under 16s, both in the UK and France. Australia's, of course, already done it. Is the whole kind of global temperature beginning to change? Are big social media companies beginning to lose the battle against regulation?
You're absolutely right. The only surprise for me is it's taken this long to get to this point. And there's only one set of interests to blame for the position we are now in, and that's the social media companies themselves. They basically decided that they could tough it out. They basically decided we've got a bottomless pit of money. We can employ the best legal brains. We can either stall or delay this change for as long as possible, and the money keeps rolling in. Well, that moment has now arrived. And so if they'd acted sooner, if they'd shown a greater degree of responsibility, contrition, acceptance of their role and so on, perhaps things would have worked out differently. But they didn't. And now the worm has turned, and it's not just happening in the UK and Europe. I cannot think of a single democracy anywhere in the world where this debate isn't hot right now.